Good morning. First, this is an important judgment wherein a person who seems to have obtained community certificate, subsequently on some complaint, his community certificate was cancelled on the ground that he was from actually Rajasthan. From there, he migrated to Jharkhand. But this judgment says AR 2023 NOC 313 Jharkhand. AR Online 2023 Jharkhand 45 says, without discussing, the committee, without discussing as to how the allegation was true that the petitioner was migrated from Rajasthan, passing cancellation of orders against the principle of natural justice. Therefore, this judgment was set aside the cancellation order. And now, as I already discussed with you, see a case wherein a girl, college going girl, lodges a complaint after a few days, stating that the accused seems to have offered 100 rupees for sexual intercourse. And the prosecution was conducted for an offence under section 451 because he entered into the house and section 8 of Pocso Act. So that is not important. Actually, our statement before the FIR was something different. Our statement before the 164 statement magistrate was different, and before the box it was different. So I want to explain how this has been brought to the notice of the court by following 161, 162 CRP, 145 Evidence Act. Here they say at the time of lodging complaint, after cross-examination, she admitted that the person who wrote the complaint was dictated by him. The person who wrote the complaint was Ilangovan. Then that time she seems to have stated that her age was 18 years. That was elicited. Then you see, when on interrogation by the police, I have stated that he offered 100 rupees for sexual intercourse, and he came out, and at that time the victim came out. So that was the 161 statement elicitation. Here then evidence of 14. Here PW2, they say PW2 means it is the victim girl. Whatever it is, victim girl, PW2. She say I went to police station to lodge the complaint on influence of political party. That was elicited. Why she has given some reasons. Then the court also put a question. You at the time of chief examination, you have stated date of occurrence was 31/1/2007. Then for that she said it's wrongly stated. Then in the police statement, PW2 during cross-examination stated that I have, when I was coming out by hue and cry, I have stated that to Pichaipalli, one of the witness relative, that was, she says, no, I did not say. They say, but I have stated only at his house. Then, but she also admit that as soon as she came out of the house, she has stated the what had happened to Susila, Kamali, Rita. That she admits in the 161 statement. That is most important. Then again, page 17. Page 17, some neighbor, she is mother, she says she could not remember the date of birth of her daughter, but she says as soon as the incidents had taken place, we have given the complaint immediately within 15 minutes. This is what our statement. Then we will go to 164 statement. No, that is not important. 24. Sorry, wait 1 minute, no problem. We have sufficient time. Then this is what witness Pichai Pillai, to whom she immediately reported after the incident. During cross-examination, the investigating officer elicited that at the time of 161 statement, I did not say that when this occurrence had taken, the victim met me immediately in front of the house and stated that for that and also denied that he has stated in 161 statement that the occurrence had taken place 4/2/2017. This is what he says. Then Vaidyaling, the stands witness, the witness who has witness for observation was a rough sketch. Then the cross examination he has stated helped the defense that the victim house and his house are very near, and everybody could see who is coming from victim's house or not. This is what he says. Then this is most important. Sub-Inspector of Police. All these are elicited through witnesses. Now he is bringing that by referring 145 Indian Evidence Act. The inspector says the FIR has stated that the complaint was received on 4/2/2017. But the investigating officer says he did not know who wrote the complaint. According to Selvaraj, the father of the victim, the allegation was 100 rupees was shown for and invited for sexual intercourse. This is what the same statement of Vasugi Pichepile Susila. Then he says, he has stated that is vital when the victim girl went out and met immediately the Pichai Pillai. According to Pichai Pillai's statement, he says that the Vasugi victim girl admitted his statement in front of his house only. So there is material contradiction. So this is the way they elicited vital important. This is what they say. You see, finally they have stated cross-examination that no such witnesses had spoken as per your statement, and he also admit that he did not show the availability of water pipe connection in front of Vasugi victim girl's house, and also the observation did not show one house of Alagu. Therefore he says, finally he says whatever it may be. Then again another witnesses, Radhakrishnan, he is the person who subsequently conducted the prosecution investigation and filed the charge sheet. Then he says that in the statement of Selvaraj Vasugi Nallammal, the date was corrected. 17 was corrected. The victim girl was examined on 5/2/2017. He also says that is typographical mistake. And it is also most important that the Vasuki, according to our statement, met to Pichai Pillai, according to statement. Then and also at the date of occurrence, 100 rupees was shown and invited for sexual intercourse. This is the evidence of and actually in the box she says he pulled her hand and thrown on the bed. Whatever it may be, this is what contradiction were elicited through cross-examination. I think you understand it. If you want further clarification, you put your questions. Best wishes.